All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. Good morning. Welcome to the Supreme Court of Texas. We'll hear argument in 3 cases this morning. The first is case number 250161, Gopalan versus Marsh from Travis County and the Third Court of Appeals. The second case is number 250297, Champion Food Service versus ProAlamo Foods from Bexar County and the Fourth Court of Appeals. And finally, case number 250317, In Re Home Depot from Harris County and the 14th Court of Appeals. The court has allotted 20 minutes to each side in each of the cases. We'll take a short break between the arguments, which can be viewed online and will be available on the court's website later today. With that, we're ready for argument in case number 250161, Gopalan versus Marsh.
May it please the court. Mr. Orsinger and Mr. Orsinger will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal. Mr. Stephen Orsinger will open with the first 15 minutes, and Mr. Richard Orsinger will present the rebuttal.
Good morning. May it please the court. The right of trial by jury shall remain inviolate. The sanctity of a jury's decision is enshrined in the Texas Constitution in 2 separate places, and it's embedded in the fabric of our jurisprudence. The primacy of a jury verdict is a matter of right, and it exists in part as a check on the discretionary power of judges. In family law, the Constitution and the legislature entrusted juries over and above judges to make the final decision on 2 of a person's most important fundamental rights: the right to designate the primary residence of their children and the right to ownership of separate property. The Family Code itself reaffirms the supremacy of the jury verdict by explicitly providing a limitation on the trial court's exercise of its discretion. Quote, "The court may not contravene a jury verdict." That's section 105.002 of the Family Code. Ultimately, this family law case before the court is about the operative force of a jury verdict on those 2 fundamental rights.
So doesn't the statute, the Family Code, also say that the court may not submit to the jury questions on issues of specific terms or conditions of possession or access to a child?
That is correct, Your Honor. And what our contention is that the jury's decision on primary residence must mean something. And what we're claiming that it means is that it establishes a threshold, a limit on
Where
the
do you get that? Because it's not defined in the Family Code.
That's correct, Your Honor. It comes from 2 places. One, there is a statutory presumption that the standard possession order, it's a rebuttable presumption, but there's a presumption that the standard possession order provides the minimum amount of reasonable access for a joint managing conservator. That's the statutory presumption. But there's a presumption that's emerged in the common law, and that is that 50% of the time, at least, is the lower threshold, the absolute bare minimum for a conservator who a jury has designated with the right to designate the primary residence of the child.
So is your argument that the definition of primary resident is really limited to residence, basically? I mean, it could mean a lot of things, primary can mean a lot of things.
Yes, Your Honor. We believe that primary does mean the actual residence, but it also has some penumbra that come with it.
Mhm.
The term primary must mean primary. The legislature used that term for a reason, and they gave that power to juries for a reason, over and above judges. And that's because we trusted the juries to make this most important of decisions. And primary residence carries with it some certain interrelated rights, but also this bottom threshold on the amount of possession time that a primary parent must be able to exercise. After this 9-day trial that we had here, the jury decided that it was in the children's best interest that Mr. Gopalan should have that right to designate the primary residence. The jury also decided that Mr. Gopalan owned a separate property interest in the marital residence. That verdict was not advisory. That was a binding jury verdict. But the trial judge, Judge Mangrum, seized that power away from the jury. She issued an order that ostensibly and superficially acknowledged the jury's verdict on primary residence, but stripped the verdict of any of its substantive meaning or force.
What if the parties were to agree um, about primary residence and further agree that um, possession didn't dovetail with that because they wanted to continue with school ties, and so the one parent is going to drive further to get their children to school or for sports or some other reason, and they're in agreement? Are they violating a constitutional principle by agreeing that one parent has primary residence but less time in actual possession of the children?
I understand the hypothetical, Justice Bland, and my viewpoint on that would be that if the parents, the parties, agree to a certain arrangement with regards to designating the primary residence, but also the exercise of educational decisions or even the possession schedule, they're permitted to do that because they're the parents of the child.
So could a parent come in later and challenge that agreement as violating a constitutional principle?
Yes, in a modification, if the circumstances had changed since that agreement was made, they could seek an alteration to that agreement or a modification in the trial court, but not based on the fact that the original agreement somehow violated the Constitution, because that's the agreement between the parents. And that's the most important thing. But here we have a jury that came in because the parents couldn't agree. And what the jury said was that Mr. Gopalan has primary, but the judge didn't agree with that. And so instead of granting a JNOV on the jury verdict on primary, she instead crafted a possession schedule that contravened and undermined that jury verdict.
You mentioned penumbras, but do you have any statutory support for that?
There's no, other than the 5 cases that are out there that say that primary, when viewed in its plain meaning, the dictionary definition of it, as Justice Triana noted in the dissent, means something. It means the most important. It means majority. And by penumbra, that's just a way of saying that we're applying the plain meaning of the term primary to interpreting the statute and seeing how far it goes to limit the discretion of the trial court. Now, the trial court parceled out possession of the children to Mr. Gopalan that was less than that standard possession order from the family code, that's below even the presumed minimum for a possessory conservator, not just a joint managing conservator. And throughout all of this, the children's voices were not heard. Both Judge Mangrum during the trial and Judge Doty afterwards refused to interview the children in chambers. The trial court also gave Ms. Marsh the exclusive authority to make educational decisions and mental health decisions for the children. Both of these orders directly contravened the jury's determination of primary residence because primary in the statute must mean.
So what if there was a jury trial and after the jury trial, the judge modified or didn't modify? I mean, when the judge was setting the terms for possession and access, which is what the judge does under the statute, and the judge at that point in time orders 50-50 time. Is that okay?
Under some of the case law, 50-50 is okay. Our contention is that 50% based on the common law presumption that has arisen over the years is the absolute bare minimum. We believe, and Justice Triana said, that at least 50%, but probably more than 50% is what's required when a jury comes in and makes a primary designation. The trial court's discretion on possession and access and the possession schedule is limited at that point to 50%.
So you would be okay with 50-50. My question also is, a lot of times, as you know, doing this a lot, you may have 50-50, but that doesn't mean all the rights and duties are going to be divided 50-50 or shared jointly, because that just may not work.
That's correct, Your Honor. And in this case, part of the problem is that the educational decisions seem to be interrelated with the designation of primary. And it's specific potentially to this case because
Well, that isn't really true, right? I mean, educational decisions can be made separately if parents are willing to, like, there's a geographic restriction here.
that's correct.
So if they're willing to drive further, educational decisions can be independent of residence.
That's correct, Your Honor, in the typical case, but this is a special one because Ms. Marsh at the jury trial specifically requested a geographical restriction to the Austin Independent School District. The jury was charged with that question, should we limit the geographical restriction to the school district? And they said no. So we know that the jury was thinking that educational decision-making authority here comes along with the designation of primary. But regardless of that, there are also issues with regards to the right to seek mental health care for the children. And in this case, Ms. Marsh was given the exclusive right. Mr. Gopalan doesn't have the right to take them to a psychologist for any reason whatsoever independently. And that's problematic for a primary conservator who theoretically should be spending more than 50% of the time with the children to not even have the opportunity to take his children to seek mental health treatment if they need it.
If we agree with you on the meaning of primary, do we really need to reach some of these other questions, or would it not be more sensible to send it back to the trial court to reassess them in light of the corrected error?
That's a good question, Your Honor, because a lot of these issues are interrelated. What our contention is that if the court reverses based on the misapplication of the statute and the term primary and finds that the trial court contravened the jury verdict, that also requires a reversal of the rights and duties, the apportionment of those, the education, the mental health decisions, but also the child support as well. And that's because the child support is a derivative issue to those two things. The court considered the amount of time that the children would be spending in one parent's residence or the other when calculating the child support amount. So that must be reversed as well. We do have other issues here, though, that raise constitutional dimensions, namely the granting of the JNOV. Here, the JNOV in this case was granted on the jury's finding of separate property that Mr. Gopalan had in the marital residence. And that has two constitutional dimensions to it. For one, it contravened the jury verdict, the granting of the JNOV, but it also divested Mr. Gopalan of his separate property, which is enshrined in the Texas Constitution as well. The trial court erred in granting the JNOV by applying the wrong evidentiary standard here, which unconstitutionally deprived Mr. Gopalan of his constitutional right to separate property.
You think every time a trial judge makes a mistake, it's a constitutional deprivation?
No, Your Honor, but in this case it is, and that's because there is a constitutional protection on a party's separate property in a divorce. The trial court cannot divest a person of their separate property.
The person still has to prove that it's separate property, right?
That is correct, Your Honor. And if doing so, if they convince the jury that they have clear and convincing evidence of a separate property ownership interest and the jury agrees with them, the judge cannot come in and contravene that unless there is no evidence. Not just some evidence, there must be no evidence.
But that's true in all circumstances. There's no special constitutional dimension for this question, is there really?
Other than the separate property link, no, Your Honor.
I mean, if you have a legal entitlement, whether it's from the Constitution or any other law, and a jury rules this way, the judge can only set it aside if there is no evidence. And that's equally true here, right?
That is correct, Your Honor. And this court's review, though, of that issue is de novo. That's a legal sufficiency review. And the elevated legal sufficiency standard that Ms. Marsh is trying to graft onto this appeal still requires this court to assume as true facts that support the judgment and disregard evidence that's contrary to the jury finding. I would like to talk real quick about the findings of fact and conclusions of law.
Before we get there,
Sure.
just to make sure that I understand your argument, So are you challenging the constitutionality of the family code here, any provision?
No, Your Honor, we're not challenging the on-face constitutionality of it. We are challenging whether or not the trial court applied it within constitutional guidelines.
So are you bringing an as-applied challenge to provisions of the family code, or are you just challenging the district court's order here?
The latter, Your Honor.
Okay. And as Justice Lerman, I think, asked you some of this, doesn't the family code charge judges with making some of the educational decisions
Yes, Your Honor.
and deciding which parent's going to make medical decisions, right?
Yes, Your Honor. That is the discretion afforded to the trial court under the family code.
And so, how if the legislature has given those things to the district judge to do, and you're not challenging the constitutionality of the statute, then where's the beef?
The beef here is with the interpretation of the statute and how much power the legislature was giving to the trial judge and how much it was reserving for juries. And that's why we say that the jury verdict here sets a threshold. It doesn't mandate that the trial court do one thing or another. All it says is that you cannot do less than this amount, and that amount is 50%. You cannot do less than that if you were a trial judge.
Or that is primary,
Correct.
resident, whatever that means.
Correct, Your Honor.
And to make sure that I have your argument on that, I think you said common law, but I assume what you mean is just it has been interpreted, primary has been interpreted by courts to mean 50, like greater than or equal to 50%.
Correct, including Justice Triana in this case, and it's just applying the plain meaning, the dictionary definition of the word primary. Here, the Court of Appeals wrongly disregarded Mr. Gopalan's challenge to 85 findings of fact, despite the practical impossibility of individually briefing each of those disputed issues. But regardless, all the findings that Gopalan challenged in the trial court were specifically mentioned and referred to in the briefing throughout the argument. Those 85 findings of fact weren't supported by the record. Ms. Marsh drafted those findings and Judge Mangrum rubber stamped them, virtually verbatim with just cosmetic or superficial challenges. But here's why that's important. Every person who reads those findings in the future will believe that they're true. The children, when they're old enough and if they're so inclined, may read them too and think that they're true. But they're not true, and they do not permit this trial court from directly undermining the jury verdict, which is another reason why we need a reversal in this case. We also have a problem with the travel bond. This is our issue 3. Our challenge to the court ordering Mr. Gopalan, to post a $250,000 bond for international travel, with the children, was not based on competent evidence. Mr. Gopalan was born in India, but the United States has been his exclusive residence for the last 28 years. He revoked his Indian citizenship, and he has been an American citizen for 10 years now. He has never expressed any intention of living anywhere other than the United States for the rest of his life. But Judge Mangrum still imposed this bond requirement.
Any further questions? Thank you, counsel.
Thank you, Your Honor.
We'll hear from the respondent.
May it please the court, Ms. Blair will present argument for the respondent.
Good morning. May it please the court. This is a contested child custody case, and I think there are 3 main points this court should consider here today. First of all, what did the petitioner ask the jury to decide? The day before the jury was impaneled in this case, the petitioner filed a pleading with the court for the first time, agreeing that the restriction on the children's residence should be to Travis County. That put this case squarely within the discretion of the trial court to make orders for possession, child support, rights and duties under the provisions of the Family Code. There is one section that I think governs most of the questions before this court today. In the Family Code, it is section 153.134B, and that is what gives the trial courts discretion to make orders in joint managing conservatorships. There's a consequence to what he requested the jury to decide, and if he had wanted more, he could have and should have requested sole managing conservatorship. That would have by default.
So it sounds like the trial judge did not even do the standard possession order for joint managing conservators, which these parents are.
Yes, that's correct.
And doesn't that seem incongruent with the jury verdict that said dad determines primary residence, So how does that departure, even from the standard possession order, how is that justified? Which could be potentially less than 50%, but even here, the trial judge didn't adhere to that.
Yes, and 2 points on that, Your Honor. So first of all, the standard possession order is a presumption. It's rebuttable. Petitioner doesn't really talk about how it should be rebutted, what evidence could be considered when it's rebutted.
How about with a jury verdict?
Yes, to that point. I would strongly encourage the court to look at the instructions the jury was given in this case. That's at clerk's record, page 1525.
So just let us know right
Yes.
now, because I think what we're struggling with, or at least what I'm struggling with, is how do you deal with this idea that the court that clearly the jury is entitled to determine who determines the right to primary residence, and they did. We're kind of lacking a definition of what primary residence means, but a dictionary, the statute that Justice Bland was referring to, etc., does give us some information about what it means, probably.
Yes, definitely. And I would say that the jury in this case was told that an award of joint managing conservatorship does not entitle a parent to equal or near equal possession of the children. So they were not misled into believing that this right to determine the primary residence meant some entitlement to a minimum amount of possession.
Well, primary residence and joint managing conservatorship seem like different concepts, so I'm not sure why telling the jury that what joint managing conservator means or doesn't mean affects the meaning of primary.
Yes. And to that point, we've cited to the court to a few cases in other contexts about what residence means. This court has described it as an elastic concept, something that has several shades of meanings. And I think sort of the heart of the issue here is, does residence mean a home, or is it some legal construct of something that is an intent? Is there an element of intent?
Aren't the cases you're referring to, though, not dealing with this issue?
That's
has
correct,
to
Your
do
Honor.
with a custody fight, basically.
Yes, but in terms of
what percentage of evenings, nights, are the children in their beds at Mr. Gopalan's residence under this order?
I actually went through a calendar this week, and it really depends on the month, actually, because the standard possession order is the first, third, and fifth weekends of the month. So it could range from 11 nights a month to, I think, up to 13 or more, depending on how the weekends fall and how all the days fall. So, and to the point about what is equal possession.
Do you have you hazard a guess throughout the year? What's the percentage of nights the children spend in their father's house under this order?
I'd be guessing, Your Honor, but I would say probably 40% or so. I'm not exactly sure.
Didn't you say it was between 11 and 13 nights a month?
Yes.
So call it 12. So 12 times 12 would be 144, roughly.
Right. Well, in the summer, though,
okay.
there's a different schedule in the summer.
Got it.
So it breaks up the summer. But sort of back to this question of what does primary residence mean? I think I think the family code sort of tells us what it means, even though it's not defined. It is really important, not just from the right to designate the residence, but where the residence is. These questions are always answered together. Who has the right to determine the residence? Where is it? So that confines, in this case, the parties.
What does primary mean?
I do agree that the dictionary definition of that means of most importance or important. Certainly, the family code only allows one parent to have this right.
And the family code seems to think it's a pretty big deal, too.
I respectfully disagree with that, Your Honor.
Give a jury the right to make that decision in 156.102 when we're talking about changing it. Well, boy, the only way we're even to talk about changing it is if these certain criteria met. One of them is the person who has the exclusive right to designate the primary residence of the child has voluntarily relinquished the primary care and possession of the child for at least 6 months. I mean, it seems as though the text of the statute is connecting the idea of primary residence with something that's a pretty big deal. Now, you tell me why you think that it's just a big pile of nothing.
Well, the family code does not connect the right to determine the residence to possession at all. It does not connect the right to determine the residence to decision-making powers at all. Where
But
I
it
think,
does seem to connect it with care and custody in the provision that Justice Young just cited.
yes, and I believe that's from Chapter 156 and the
156.
modification suit. So I do think
But
that
it's telling us what it thinks about this concept.
Right.
We're modifying something that's such a big deal. It makes it very difficult to do it only in certain circumstances. And here are the bases for being able to make that modification. It doesn't seem plausible to me
Mhm.
that the statute thinks that it's just no big deal.
So I do think that the right to determine the residence, as another example in Chapter 156, we're kind of into the modification statutes here. If a parent wants to modify the primary residence within a year, it puts a really high burden on them. If they want to modify the primary residence at a temporary order, it puts
Why would it be such a big burden if it's just no big deal and a judge can just do whatever she wants?
So, I kind of stepping back from this question, and I will answer your question. What the petitioner is asking this court to do is going to conflict with other provisions of the Family Code. And so in answering this question about what does primary mean, I think we have to look at it in the broader statutory context. The Family Code used to say that the parent without the right to determine the residence would presumptively have a standard possession, meaning less possession with the children. It used to say that there should be a primary physical residence for the children. It no longer says that. And it also allows parents, if they agree to a geographic area, to have no primary. So I think the legislative history of these statutes show us that there's a movement away from this primary designation.
If the trial judge had awarded one night a month to dad,
yes,
would that be violative of the jury's verdict?
Not of the verdict, but of potentially of other sections in the Family Code. So there is.
So jury says primary residence is dad. Trial judge says one night a month with dad.
Yeah. So there. I've cited this court
consistent.
Right, and I've cited this court too. It's an opinion from this court. It's actually a different topic, but the JJRS case this court decided several years back, and it deals with restricted possession schedules. There is a Family Code provision already saying that you cannot unnecessarily restrict a parent's possession time. So I think one day a month would definitely fall within that statute of that being sort of unreasonable. Certainly on this record, that didn't happen.
So what is within the whatever bundle of rights that's conveyed when a jury says that dad gets to exclusively determine primary residence? What is within that? Is it just a label?
I think in this case, it has very little meaning. These folks, when they went before the jury, there was very little daylight between what they wanted. They both agreed to joint managing conservatorship. They agreed to a very, very narrow geographic area, so either AISD or Travis County. That's a very, very narrow dispute.
I'm just asking a legal question. What does it mean in the law for a jury to say that somebody is the one who makes the determination for primary residence? What is that person entitled to? Is it just to say, I declare that it's this thing, but then there's nothing in the real world that connects to that? Or is there anything in the real world that connects to that?
There is something in the real world. And that's when a modification comes down the road. So it requires a parent to live in the geographic area where the jury determined they should live. And when it comes time to modify that, and let's say that my client decided she wanted to move to New York, she would then have to go and prove a material and substantial change to change that primary designation. I would also
But that's true even without the jury verdict.
That's true. Yes, and I respectfully to my friends on the other side, they've only cited one constitutional section to this court, and it's in our Bill of Rights. There's been very little briefing on what that means and what that bestows upon him.
Well, even leaving aside the Constitution, here we have a statute that talks about what the jury determines and what the judge determines, and so we're trying to harmonize those statutory provisions.
Yes, and so 105.002 is the jury section, right? And it sets aside to the trial court the right to make possession orders, child support orders, and the like. And these division of duties between judge and jury are not unheard of in other circumstances. That happened in this case. The jury answered questions about fault, but the judge came in and made the property division, right? We divide these duties between judge and jury. And just because one body makes one decision and the other makes another doesn't mean that they're conflicting with each other or contravening one another. This is just what the legislature decided. They
But
have
they
decided.
could be. I mean, they could be conflicting, and the
Mhm.
Constitution is what tells us who wins when that happens,
Mhm.
right? I mean, inviolate is pretty clear.
Well, my understanding of that provision of the Constitution, though, is that it's meant to preserve a jury trial in causes existing in 1876.
But even
And
aside from the Constitution, again, the statute says that the judge cannot contravene the jury's verdict.
well,
Then it raises the question: what does the jury's verdict actually mean? So that the judge, you're basically saying it's impossible for the judge to contravene something that the statute says the jury must be able to decide.
well, so the precise language of that statute is that the court may not contravene an issue submitted to the jury in the first instance, right? So here that would be which joint managing conservator has the right to determine the residence and where that residence is going to be. This court confronted this issue in the L.L.C case more than 20 years ago. That's a really clear example of a contravention. So the jury decided that mother could move to Germany, and then the trial court came in and put a geographic restriction of Bexar County on the children's residence. That's a really clear example of contravention of a verdict. That certainly did not happen here. And two, if I think we have to look at the actual order signed by the judge in this case to have this discussion about, what does this mean? Here, it means that all the parties are going to be living in Travis County, living near each other, having the ability to participate in the children's activities, go to doctor's appointments, all the things that parents want to do day to day. Restricting their residence to this small county is a benefit.
But that could have happened and still the court could have abided by the jury verdict. Say, for example, by, requiring that they all live in Travis County, but that the possession would be at least 50%, or let's say 51-49, to the primary. I mean, I think a lot of what you're arguing that there's that the law statutorily and otherwise, really throughout the country, is evolving towards not awarding labels and just looking at this as two parents, children, parenting time, all of that.
Yes.
And that's probably it's very well documented throughout the literature and just the statutes throughout the country. But in Texas, we're not there. In Texas, the statute says what it says. And so that's why we really have to get to how what that definition of primary means in this context.
Yes. I think the trouble with what the petitioner is asking this court to do, though, is that it will contradict. We will now have a minimum possession associated with primary and a standard possession order. I don't understand how those things will function together. I think that will create a lot of confusion for practitioners and trial judges.
So we often say that statutory terms should be interpreted based on their plain or common meaning. Just what would these words mean to, a person of ordinary intelligence and education?
Correct.
And so primary residence. I struggle to see how any regular person. So let's set aside this or that provision of the family code and how it all interacts, but just. Is there an argument that any reasonable person could look at this custody arrangement and be asked, is the primary residence with the father or with the mother? And the person would answer, oh, it's with the father. I can't imagine anybody answering that way to that question, looking at this custody arrangement. Can you?
I can, based on the family code. I think there's a very simple explanation for what.
So I asked you to set that aside.
Yes.
And just how would a regular Texan think about the concept of primary residence?
Right.
Under a regular Texan's concept of primary residence, could any reasonable person answer that the children's primary residence is with the father under this arrangement?
In terms of what the legal meaning of residence is, I don't. It's very difficult to define what that is. So I understand the meaning of the word primary, and I think residence can mean a home. I think it can mean other things. I think it can mean a lot of people have more than one residence, right? So how do we define what is the primary residence or what is the
Yeah, but
secondary.
they're not talking about doctors getting trained or something.
Right.
This is in the family context.
Mhm.
Let me ask you this. Under the district court's order, could Marsh send the kids to school in Waco?
I think that would be very impractical under the court's order. She does have the exclusive right to make decisions, but the possession order in this court's order would make that functionally impossible to happen.
Why?
So, well, a lot of these orders have provisions for based on where the parents reside, right? So one parent lives 100 miles away from the other, and here's the schedule.
Mhm.
This order applies regardless of where the parents live. So it'd be completely unworkable, in my opinion, if for her to do
But
that.
if hypothetically, if Marsh got a helicopter and said, "I've
Mhm.
decided I'm going to fly the kids to school every morning in Waco, go pick them up," would Marsh be in contempt of the district court's order?
But by just functionally enrolling them in school in Waco, no, she would not
Okay.
be in contempt.
And so, isn't one way that we would think about primary residence, in addition to where you lay at, where you keep your clothes and your food or
Mhm.
whatever, isn't primary residence usually how we would decide where kids go to school?
It is not, Your Honor. Under the education code, I've cited the court to this in footnote 7 of our brief.
Thank you.
A child can attend school either tracking either parent's residence, so it is not confined. I know there's some sort of statements in these cases that we've all cited you to saying that, but I don't believe that's an accurate
Well,
representation.
isn't there a specific right that's awarded to make educational decisions?
Yes, and
So-
the family code allows the court to award that independently to either party, or exclusively to either party.
But
So-
isn't that kind of odd that these two things would be in conflict? That basically the jury gets to decide primary residence. My understanding of the family code is that the judge gets to decide who's going to make the educational
Yeah.
decisions, and these things are pitted against.
So
each other.
the judge and the jury heard different evidence in this case that directly goes to this point of educational rights. So Mr. Gopalan repeatedly told the jury he was going to stay in the same neighborhood, which is where Miss Marsh also lived. The children were going to stay in their same schools. And within 2 weeks of getting the verdict, he relocated without telling my client, came to court, and then testified outside the presence of the jury that if given the right, he was going to immediately change their schools. This empowered the trial court to step in and prevent the disruption of the children's schools, changing their schools, and the trial court's empowered to decide that
If the trial court turns out to have been mistaken in thinking about the possession in light of the jury's verdict about primary residence,
Yes.
what should we do with respect to these other issues? Should we send them back to the trial court for reconsideration? Do you think they would independently stand despite that?
They should
error?
independently stand.
How can that be?
These rights are not connected under the family code.
But wouldn't they possibly be connected for the same reasons Justice Sullivan was just talking about? I get they might be different ultimately, but wouldn't a sensible judge think, well, I should probably, if it turns out that the residence, the possession,
Mhm.
whatever is going to be over here, maybe I need to factor that in a different way when thinking about some of these other rights. But if I'm going to able to give it to the mother, well, then sure, I'm going to give her some of these. And that's what she thought. So if we disabuse her, assuming that's wrong, I'm not prejudging it,
Yes.
then would we not want to at least remand it for her to reconsider those things?
If I may answer the question. I think a fundamental part of appellate review is identifying error under a statute, or perhaps there's insufficient evidence for what a trial court did. Petitioner has not done that here. Not only that, he has not cited this court to the controlling statutes on the exercise of rights and duties. So I think if he doesn't come to this court, identify an abuse of discretion by the trial court, that this court should not reverse and remand those issues. If it does, I think it should be for a new best interest analysis.
Well, so I have a question. So I'm
Yes.
not really following the disconnect between, let's say, if, and this is totally if, we were to find that that the trial court abused its discretion by awarding less than 50% possession to the father,
Mhm.
that I'm not following how that conflicts with the other parent having the right to determine the educational decisions of the child. I mean, it seems pretty frequent that happens.
It's not unusual. I mean, all over the state every day, trial judges are dividing these rights up, right? And it is very fact specific to each case. The trial court made some determinations here that Ms. Marsh would be the parent better entrusted with making these educational decisions. So it was a best interest determination that was made and should not be reversed absent the showing of an abuse of discretion on that topic.
I wonder if we're over time, but you haven't had a chance to talk about the separate property. And
Yes.
I'm wondering why it is that the jury couldn't have credited his testimony.
So very briefly on that. So I believe that the petitioner has applied the wrong standard of review here. It requires evidence, supporting a firm conviction or belief of the
But
things.
even given the standard of review that you present.
Yes. So he's really asking this court to take him at his word how this money got from a 401k into this house.
He's asking the jury to take him at his word,
And they did, right?
Pardon me?
The jury did take him at his word, it seems, right?
Right, but under the burden of tracing, which is required for proving a separate property claim, you must trace the money from the 401k to the house. So we know he took the money out of the 401k a few weeks before they purchased this house. But then the record sort of goes cold on what happens. His testimony. And also I'd point out there's a magic number here he has to prove. Both of the parties agree to this number. In their post-trial pleadings, it's $18,446.83. That's what he was claiming is the amount of money he put down on the house. So he says he put it into the bank account. There are no bank account records. He has provided no testimony or evidence on what was in that bank account. He does absolutely no tracing through that bank account to the actual purchase of the house itself. His testimony is, I imagine I wrote a check, so I don't have the exact number. I can't get the records. I would like to say it was 50-50, meaning he and Ms. Marsh split the down payment. But that leaves us to speculate where that money from the 401k went, and whether it went into the house or not. And that's the test.
Why isn't that testimony at least to scintilla? You mentioned that it's tracing here. Is there a statute or something that says that if your bank records are lost or something like that, then I guess there goes your separate property?
There is a lot of support in all of the intermediate appellate courts on this question of, yes, you either need to have bank statements to show it, or you need to clearly trace the money through some other method, right? And he just did not do that here. And I would encourage the court to review the McKinley case. This is an opinion out of this court from several decades ago, and in that kind of talks about this wholly inconclusive nature of the evidence as to where the funds were deposited and withdrawn. So I'd encourage the court to review that case. Not exactly analogous, but
Thank you.
Thank you. Any further questions? Thank you, Ms. Blair.
Thank you very much.
Mr. Orsinger, you have 5 minutes.
Thank you, Mr. Chief Justice. I had the honor of appearing before this court 24 years ago representing the mother in Lenz versus Lenz. And in that situation, the jury verdict permitted her to establish the primary residence of the children anywhere, including in Germany. The words Germany were not in the charge, but that was what the trial of the case was. And the district judge countermanded that. And there was no case law that stopped it. And the Court of Appeals affirmed the trial court 3-0. And we came to the Supreme Court and presented our argument, and the court unanimously decided that the trial judge is bound by the family code provision that says you cannot contravene the verdict of the jury. Since Lenz was decided in 2002, we've had 6 Court of Appeals decisions. 5 of them said if you get the verdict on primary parent, you should have at least half of the time. Several of those 5 said it should be more than half of the time. And then along comes this case, the 6th one, that says it's okay if you get less than the minimum visitation for a possessory conservator. And Justice Triana disagreed with that and wrote a very good dissent, which I'm sure you all have read. I was planning to quote part of it, but I think my time is too limited. But I would point out that
Your friend on the other side suggested the children spend roughly 40% of nights at
I
their
have an
father's
exact
house. Is that
calculation, Chief Justice, for that. We ran the statistics, and the answer to your question is what is the percent? It's 43% of the time with the father and 57% of the time with the mother. It varies slightly depending on a calendar year, but that's essentially the bottom line. Now, in terms of overnights, basically the trial judge eliminated weekend visitation for my client during the summer. So as a practical matter, instead of getting the children on the first, third, and fifth weekend of every month during the summer, he gets 0. Additionally, the judge allowed Miss Marsh to select when his summer visitation would be. So he can't even plan his own vacations with the children, even though under the family code, he should be entitled to select. So that 43, 57% is a mathematical calculation, but as a practical matter, imagine having all of your visitation in the summer suspended for no reason. So that's the answer to your question, Mr. Chief Justice.
If it were cranked up by 7.1%, would that solve the primary problem?
I'm not here advocating that 50% is primary. If you read some of these Court of Appeals decisions, they say if you split the time 50-50, the children essentially have 2 primary residences, and the one who's supposed to be primary can only control half the time. And as this court said in Story versus Etheridge last May, possession is the parent's right to influence. In other words, the parent can only influence the child during their periods of possession. And if you have the primary residence, but you don't have more than half of the time, then you have 2 homes. And the Corpus Christi Court of Appeals said that. Now, I wanted to clarify, Your Honor, the issue about the constitutional question on the property side, the constitutional, and Justice Young, you asked this. The reason that the verdict on separate property is a constitutional issue is because the trial court took Mr. Gopalan's separate property and gave it to Ms. Marsh. And the Eggemeyer case, decided by this case, Eggemeyer versus Eggemeyer in 1977, said the Constitution prohibits taking one spouse's separate property.
And the premise of that is that it was a separate property.
Yes. So we have this issue about the sufficiency of the evidence, and of course the trial court granted the JNOV based on it. It wasn't clear and convincing. Well, that's the fact finder standard. That's not the appellate standard. But my client's testimony was corroborated by a tax return filed at the time that took the credit for taking the money out of his premarital 401k, and he got the house exclusion for using the money to pay a down payment on a house. So it was corroborated. And we believe it was the jury's prerogative to believe the evidence if they wanted, and Justice Triana said exactly that in her dissenting opinion. So let me point out that the reason that the decision on possession is a constitutional issue is because Article 1, Section 15 says, yes, the jury trial is right to jury trial is inviolate, but the legislature shall pass such laws as may be needed to regulate the same and maintain its purity and efficiency. So this statute that says it's the court, the jury verdict is binding on the court on the issue of primary custody, it's part of the purity and efficiency clause of the Constitution, and that makes this a violation by the court of the Constitution. There's nothing.
Primary residence.
I'm sorry.
Not primary custody.
I shouldn't have said that, but it's a kind of a loose hand way of speaking, but you're exactly right, Your Honor. It's the primary residence issue. So I see my time is up. I wish there was more I could say, but thank you very much for your time.
Any further questions? Thank you, Mr. Orsinger. Thank you to all counsel. The case is submitted, and the court will take a brief recess.
All rise.
Please be seated. We will hear argument in case number 250297, Champion Food Service versus ProAlamo Foods.
May it please the court, Mr. Vargas will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Good morning, Mr. Chief Justice, and may it please the court. This case presents a straightforward legal question, and the law has long been clear that you can't get recovery on quantum meruit whenever there's a valid, existing, enforceable contract that covers the same materials, the same goods, or the same services at issue. And here, what we have is a trial court that submitted questions to the jury on both breach of contract as well as quantum meruit, not conditioned on whether or not a contract existed, but instead conditioned on whether or not the plaintiff prevailed or lost on their breach of contract claim against Champion.
Who bore the burden of asking or ensuring that the quantum meruit question asked about work done outside the scope of the written, or in this case, oral or invoiced agreement, outside the scope of the agreements?
Ordinarily, the defendant would have, but we did. We met that burden at the charge conference, Your Honor, because we repeatedly requested instruction or a question to the jury on a predicate, right? What were the terms? What was whether a contract existed, and what were the terms of the contract? And at the end of the day, what the trial court judge did at the respondent's invitation was find that there were valid agreements. In other words, the way that this case was pled in the live pleadings and summary judgment motions and argued at the trial court was that there were valid oral agreements, and only in the alternative should there be a submission on a question on quantum meruit. Instead of doing that, what the trial court ended up doing is including the quantum meruit question, not conditioned on whether or not a contract existed, but instead, if the respondents lost and there was a finding that Champion didn't breach the contract, then you go straight into quantum meruit. So in other words, what happened and the way that this jury charge—
Do you agree that your client accepted some benefits in the provision of meat?
They did. And I think it's worth taking a step back, Your Honor, as to how these contracts were structured. In other words, what nobody is arguing is that somehow there were unilateral shipments of meat that were sent by the respondents to Champion that Champion then benefited from and refused to pay for. Instead, what everybody agrees on and what the record clearly reflects is that the way that these contracts were structured was that Champion, who is a distributor of meat directly to restaurants, who then sell to their customers, would place an order for a specific amount of meat to the respondents. The respondents would then deliver the meat along with an invoice that clearly identified how much was supposed to be paid in exchange for that meat. And then then Champion would pay for that meat until they started getting complaints from the restaurants that they supplied to that the meat that was being delivered to the restaurants that had been supplied by the respondents was rotten and rancid. And only then did Champion decide that it wasn't going to pay for that portion of the meat. But what nobody is arguing, and what the record doesn't reflect, is that somehow there were shipments of meat that were coming to Champion that fell outside of the scope of what the agreements were. And in fact, the jury charge that was submitted to the jury referenced agreements in two places. On question 1, there was a question on valid agreements. And then question 6, there was a question on agreement. And in both instances, the jury found that Champion had not breached the agreements, and instead that the respondents had breached the agreement in question number 6. And that submission—
Why is it that question 1 uses the plural agreements? And then question 6 speaks of only one agreement. What am I to make of that? How do I know which of the multiple agreements question 6 refers to?
Yes, Your Honor. When you look at the record, what was being argued in the term of agreements was the different invoices, right? In other words, there were multiple payments for multiple invoices for different shipments of meat that came with those invoices. And that's how the respondents pled their claim, right? In other words, there were oral agreements to ship meat and pay the invoices. On our side, what our claim was on the breach of contract was, and this was discussed during the charge conference, was that there was an obligation to provide meat that wasn't rotten and rancid. In other words, it was fit for human consumption. And so that was the breach that was referenced on question number 6, which was our question on an agreement, as opposed to the question on the multiple invoices. And the way that it was couched by the plaintiffs was oral agreements to pay the invoices for the multiple shipments of meat. But the most important point is that nobody is arguing that there were shipments of meat that fell outside of that course of transactions between the respondents and between Champion. In other words, there was never a shipment of meat that came to Champion unilaterally without Champion first picking up the phone, placing a very specific order, and then a very specific invoice accompanying that shipment of meat being sent to Champion, which it then paid for.
So it sounds like what you're arguing two things, and I want to be sure I understand, because I'm not sure either one of them is the argument in the brief. So I want to be sure I understand the argument here. So one argument seems to be charge error because the trial court didn't submit a predicate question on the existence of the agreement defining what the scope of the agreement was. But I didn't see you complaining about that and asking for reversal on that. Is that correct?
We're arguing both, Your Honor. In other words, we are arguing that there was charge error at the charge conference by refusing and omitting the question on the predicate question on breach of contract. In other words, as to the terms and the scope and whether the contracts existed. But separately, we've appealed and we're asking for relief on the court's refusal or the court's denial of Champion's motion for judgment notwithstanding verdict.
Because there's conclusive evidence of that each one of these was a contract on theirs, that this oral agreement to pay for each separate invoice was a separate contract, and therefore there's no quantum meruit.
Well, what the evidence shows, Your Honor, is that there were valid oral agreements that were pled for by the respondents. And at the charge conference, even though we requested a predicate question on whether that existed and what the terms of those agreements were, the trial court, at the respondent's invitation, took that out of our hands. In other words, the trial court said, we've heard evidence as to these agreements, and what the trial court found at the respondent's insistence, in fact, what the respondents argued was, it's not necessary in this type of situation to include a predicate question because there's no question that agreements existed. And so we don't need to clarify the terms or the scope because the agreements exist and there's no fact issue. And at the respondent's insistence, that's ultimately what the trial court did, is it found by going with the broad form question under the PJC that went directly to breach, the trial court took that issue out of our hands, found the existence of a contract, and then whenever the jury...
It sounds like, though, that you're not contesting the existence of a contract. You're really contesting the quantum meruit question because it did not focus on work done outside the existence of the agreements.
We're not contesting a contract. And at that point, that issue is not at issue in appeal, Your Honor, because the trial court, like we said, took that out of our hands by submitting the questions to the jury in the way that it did. And then whenever the jury ended up answering the question on breach, and under the Mincer case and under the Christus case, which you authored, Justice Bland, the holdings in both of those cases were very clear that once a jury answers a question one way or another on whether or not a contract has been breached, then there's an implicit finding that a contract existed. But once that contract...
Right, but the difference between this case and the Christus case is there's an argument, at least, that here your client accepted benefits that were not covered by the contract. Whereas in the Christus case, it was all in or all out because the contract required, pre-authorization, and nobody was really arguing that there wasn't a contract.
Well, in the Christus case, what you had, that's right. In other words, there were clearly defined contracts in several of the cases that discuss whether or not you can obtain quantum meruit outside of the scope of a contract. In other words, there are certain cases in which you can get both an instruction or a question on breach of contract, and then separately a question on quantum meruit. But
like
those,
Goolsby, which is also out of our court.
that's right. But in all of those cases, what you have are very defined, limited in time, limited in scope contracts. And that's what you don't have here. In other words, there's not a contract that was very limited in scope, and then you have provisions of materials or goods that fall outside of the scope of that contract. And we attempted to cure that issue by requesting the predicate question on the terms of what the contract was. Now, when you have a respondent who's pleading solely in the alternative quantum meruit, what they're requesting from the court and from the trial court is, we want to move forward on our breach of contract claim. In other words, if a jury doesn't find that a contract exists, then we can move on to a quantum meruit question, and that quantum meruit question should be conditioned on the existence and the terms of the contract itself. Instead, what you had here is a trial court that instructed the jury that if the plaintiff loses, now respondents loses on their breach of contract claim, then you go to quantum meruit. In other words, at the respondent's invitation, it was set up in a way that they couldn't lose. The jury was charged with heads, I win, tails, you lose. And that was an improper way to charge the jury on quantum meruit, because quantum meruit is inherently incompatible with a breach of contract claim whenever you have a contract that covers the materials and goods at issue, which is exactly what was pled by the respondents, what was argued by respondents in their live pleadings and their summary judgment motions at trial, at the charge conference, at their closing arguments, as well as in post-trial motions. In other words, at no time did they ever take the position that somehow there were goods and services that were outside of this course of transactions that formed the basis of the oral agreements that they sued on. It was solely in the alternative that they sought a quantum meruit question from the court, or quantum meruit relief, at least. And so...
Oh, sorry, finish that thought.
You go ahead.
I wanted to ask about attorney's fees. Our precedents seem, I don't know, kind of vague and open-ended and discretion-heavy. Are there, in your view, clear guardrails or parameters on determining reasonableness of attorney fee awards?
Well, here's what I think what's important from the briefing, Your Honor, on the attorney's fees issue. Number one, we don't get to issue 2 if the court sustains issue 1, because there's no avenue for attorney's fees if they don't get quantum meruit. That's clear. So if the court agrees and sustains issue 1, we never get to attorney's fees because there's no avenue under Chapter 38 of the Texas Civil Practice and Remedies Code. But if the court disagrees with Champion on issue 1 and starts examining in detail the attorney's fees issue, we think that even then the jury finding of 0 fees is appropriate. And the reason why is that when you look at cases like Garcia, for example, that talk about the results obtained being the most important and critical factor, when you look at some of the factors like the amount in controversy, and when you look at
Well,
the fact...
but what do you have to say about Rormus, where we talked about the lodestar method, and where we have said clearly that the Arthur Anderson's factors are subsumed within the lodestar method?
When you start looking at all the factors, Justice Lehrman, and you look at what the amount of controversy was, and there was clear testimony on, it was a little bit north of $70,000. The results obtained were slightly north of $40,000. The amount of attorney's fees requested were somewhere in the neighborhood of $219,000.
But that's not answering what I'm asking about the lodestar. That's really focusing on the results obtained, and we were pretty clear about the Arthur Anderson factors being subsumed within the lodestar. So what is your response to that?
Well, I think that there's a basis, Your Honor, whenever you start analyzing the Arthur Anderson factors and the testimony as to whether or not it was necessary to incur these fees. In other words, reasonableness is a fact issue. under the case law. When you start looking at the different factors and the evidence that the jury heard, that there were multiple attempts to work these issues out before a lawsuit was ever filed. For example, the jury heard evidence that there was even an agreement that was reached to reduce the amount of invoices based on how much rotten meat had been delivered to Champion, and that there were multiple offers to try to get this issue resolved before the litigation was ever filed. And they had a tentative agreement.
Counsel, before your time expires, I'm going to flip past the picture of small intestines on page 16 of your brief. Can you just walk me through the decretal language on page 41 of your brief? So you say you want us to reverse, render judgment for Champion on the pro parties claims, and then remand for a new trial on your claims. So just how do we get to there on the heads I win, tails they lose kind of thing?
What we're asking the court, Judge, just to clarify, Your Honor, is we're asking the court to reverse the Court of Appeals and render a take-nothing judgment. That's the request that we're asking for today, both on quantum merit as well as fees.
So you're no longer asking that we remand for a new trial on Champion's claims?
We're not,
okay,
Your Honor.
But before you sit down, I want to make sure that I understand on fees. Your lead argument is zero. Obviously, your lead argument is zero because you win on one, but assuming you don't zero, the jury could reasonably have decided zero. If we decide no, that's improper, there's no evidence of zero, your next argument is it's got to be a new trial, despite the fact that there was no real contravention of the reasonableness of these, other than the very thing that you think means that the jury
We'd ask the court to, in other words, if the court says that it was unreasonable for the jury to award zero, we'd ask the court to remand for a new trial on fees, Your Honor.
So Justice Hawkins mentioned that our cases seem to suggest sometimes that we're gonna take them out. It's a matter of law. You get what it is unless that amount is unreasonable. Now, you said a second ago that that's a fact question, but that can't really be what our cases are talking about, because the court, as a matter of law, said this is whatever we meant by unreasonable enough to then send it back to a jury. What is that standard? How do we decide when something goes from being, as Justice Lerman was describing, well, this is the lodestar, they got some recovery, we're gonna, we don't think there was anything that really put this in factual doubt, versus, well, that just looks like it's too much, it's unreasonable, so we're sending it back to a jury. Where is that line? What is your test?
Well, and so on the JNOV, which is what was granted, in other words, what the trial court did is they granted a JNOV that the respondents requested and filed. And what the trial court did is it granted the JNOV, and what the trial court had to have found on that standard, Your Honor, is that there was not more than a scintilla of evidence to support the jury's verdict. And we think that here, there was more than a scintilla of evidence to support the jury's verdict of zero fees. Why? Because the jury heard.
So I'm saying move on beyond that. Okay. I'm in the world in which we conclude there is no evidence of zero. How do we decide whether it's the full thing, which is what the Court of Appeals majority did, versus when it descends to some level of unreasonableness in light of the results or whatever, and we say, well, no, that's different. This is Smith. This is whatever else. We need to send this to a jury. I don't understand where the test is. Is it just the gut of the court that does that?
I think the court looks at the record and factors in that it's 100% completely uncontroverted, right? In other words, if the evidence was fees, was completely uncontroverted, then at that point, it wouldn't need to necessarily remand for a new trial on fees. But that's not the situation that we have here.
Is that really consistent with our decision in Barker versus Ekman to remand for the jury to decide to have a new trial on fees based on a change in the solely in the amount involved and results obtained without considering whether the evidence was controverted on the lodestar?
I think it is proper for the court to consider whether the evidence was controverted or not. And what we submitted to the court and briefed and what the record shows is that the evidence was controverted. It was controverted because there was evidence on a cross-examination as to what the amount of controversy was, whether it was necessary to incur the $219,000 plus in fees that were incurred, and evidence of what the pre-litigation transactions and negotiations of the party were. the parties were. And so, in other words, was it even necessary to incur these fees because of the negotiations and the attempts to resolve this beforehand and the offers to pay for the unspoiled meat, Your Honor?
Any further questions?
Nope.
Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Chirazis will present argument for the respondents.
Mr. Chief Justice, and may it please the court. There are three main reasons why the court should affirm the judgment below. First, there is no express contract here that precludes a claim for quantum meruit. Champion does not point to an express contract and failed to seek the required findings necessary for there to be preclusion.
Well, you don't have to have an express contract to have a contract. It can be oral.
Yes, sir.
Or it can be by performance,
Yes, sir, but it needs to be expressed to cover what is at issue in the quantum meruit claim.
So they say you told the trial court, don't submit a question on that to decide what the contract is and what its terms cover because it's undisputed. And now you seem to be saying it's not undisputed. So what are we to do with that?
So first off, Your Honor, we said that there were agreements, okay, multiple oral agreements, which of course the jury disagreed with. And they did say no, and under rule.
Well, no, the jury didn't disagree with that. They weren't asked to find whether there were agreements. They were just asked to find whether there was a breach.
Yes, Your Honor, but we don't know what the intent of the jury is. And under Rule 279 and under the
Well,
locals.
sure we do, because you represented to the trial court that there was no dispute that there were agreements. So if there's no factual dispute, then we know the jury had to assume there were agreements because the evidence is conclusive on that.
Yes, Your Honor, but that is argument. That is not the evidence, and that is not what the jury found.
Well, what I'm wondering is, does it make sense for a party to be able to tell the trial court, you don't need to submit this issue to the jury because it's undisputed that these are covered by agreements, and then to come back and say, well, they're not?
And Your Honor, I would say yes, and I think what we need to do is we need to go to Champion's pleadings as well for this. And if we look to specifically in the record on page 125, in the Fortune Products case, this court held that you can have express agreements and you can still have quantum meruit if there are products and services that are outside of those agreements.
So what's the evidence of that here? That there were products and services outside the agreements?
Yes, Your Honor. So if we go to the record, and specifically in the 12th reporter's record in Plaintiff's Exhibit 2, and we look at Champion pages 5, 6, 8, 10, 11, and 14. One of the things that you will see in each one of those is that there are changes to what the invoices are submitted. It's not just changes in the product quantities, it's changes in product prices, it's changes in the entire amount. There may have been an agreement before about the pro party submitting a certain amount of product at a certain price. That was changed at the time of delivery. That was not, there is no evidence shown, they haven't provided, that says that there was some sort of agreement that was reached there. And the jury could have looked at that and said, we don't think that that is part of an agreement. That is part of products that were provided.
Was the jury told only look to those transactions for which you have, for which there was no agreement?
No, Your Honor, they looked at the entire thing. But what the jury did find is that there was approximately 46,000 of the 73,000 that was being sought that they found in terms of quantum meruit.
Right, but that, I mean, the worry there is that it might be some sort of mitigation idea that some of them, that maybe it shouldn't have rejected the entire shipment. And that would, of course, go to breach of contract damages, but wouldn't be recoverable in quantum meruit. And so without the jury being instructed that anything you find in connection with quantum meruit has to be amounts accepting benefits that weren't covered by an agreement.
Right, and just to be clear, Your Honor, the Champion did not request that and had the opportunity. They had their own breach of contract question, and they did not submit the predicate question of what is this agreement?
Well, they asked you on yours, and you told the trial court, I mean, tell me if you didn't, I'll go read the charge conference for myself, but I'm hearing your argument that here's the evidence of the transactions for which you say there was no agreement. And then they said what you told the trial court in the charge conference is it's undisputed that there are agreements. So how are those things consistent? Or is that not what you told the trial court to induce it not to ask the predicate question?
Well, to be clear, so we did say that we believe that there were contracts, that there were agreements, Your Honor. Okay. We also had Champion at the same time say this is not a contract case. There is no contract, even though it's submitting its own contract claim. And the court relied on, and one of the first things the court did in terms of that objection was it said, well, you don't have a predicate question for your own contract claim in question number 6. Also, again,
that doesn't get you off the hook.
Well, but getting back to the Fortune Products case, Your Honor, as it talked about, it said that the deciding whether or not there's an express contract is an affirmative defense. Okay, Champion never pled an affirmative defense that there was an express contract that covered the quantum merit claim, that would say that the quantum merit claim couldn't stand. And I understand that there may be some charge error here, but this is either harmless error or it's been waived at this point. Because what we have, and the only way to read the jury verdict in conjunction with the judgment, is to say that there is not a conflict between the quantum merit claim and the breach of contract claim that was found, in that that agreement was different. And to getting back to your question, Your Honor, in terms of in the briefing and what was briefed there, I mean, specifically what Champion said in its briefing here, and that's on page 13 of its brief, it says, after the pro parties reneged on an agreement to settle the account, the parties sued each other for breach of contract. Again, it is not clear what there is in terms of the express contract.
So why wasn't it submitted to the court? Why wasn't that submitted to the jury?
I'm sorry, I don't understand, Your Honor.
Well, you said it's not clear what's covered by a contract and what's not. So shouldn't that have been submitted to the jury?
If they would have pled that an express contract subsumed or precluded the quantum merit claim, yes. But they didn't do that. They didn't plead it. And as the Fortune Products case said, that is an affirmative defense, and many courts have said that's an affirmative defense that has to be pled. So it wasn't error for the court not to do it, and I believe the court didn't do it because, first off, they Champion said to the court directly, there is not a contract here. And second, it didn't submit its own predicate question that said, what is the agreement and what does it cover? Just briefly, as we've talked about a little bit, the second point here is that there's nothing in Rule 279 or the jury verdict that assumes an express contract precludes quantum merit. And it is their burden to make those to ensure that those findings are made. They had that opportunity. They determined not to do it.
Mr. Terrazas, can I ask about the fee issue? I guess.
Yes, sir.
I don't know. We'll try to build a hypo here. I think there are now lawyers in the state charging north of $3,000 an hour. Let's say I've got a breach of contract claim. It's worth $50,000, and I want the best lawyers in Texas to litigate this thing. So I sue. I hire expensive lawyers. I win. I rack up $1 million in legal bills, and I get the full $50K judgment I want. Do I get the full amount of fees?
No, Your Honor, you don't. And why is because we go back to roar moose. And the key here is that Smith does not eat roar moose. Roar moose establishes that the first thing you have to do is to determine a lodestar. The reasonable hours multiplied by the reasonable rate. $3,000 an hour for a $3,000 case is not a reasonable rate, and it's not.
Well, how do we know that? Is that just vibes, or is there some?
No, Your Honor. I think that that's based on the evidence. And here, what was presented and is uncontradicted was that the reasonable rate here of $400 an hour, if that same case would have come in and there was evidence that supported that that was not a reasonable rate for the services that were rendered, and it wasn't reasonable for the jurisdiction and those type of things, then that would go into exactly what roar moose is saying.
It just seems very. Oh, sorry.
No, please go ahead.
It just feels very unsatisfying to me. It feels very sort of ad hoc and made up. This idea of like, well, what's a reasonable rate to charge a lawyer, like depending on the value of the. Isn't there some guardrail or like actually defined parameter that we could use to figure this out instead of just going off of subjective ideas about what seems okay?
And Your Honor, I actually wish there was, and there used to be some attorney fee studies that were conducted by the Texas State Bar over the years, and they would determine what would be the median rates for the different jurisdictions and those type of things. And I've used those in terms of fee disputes before. But I will tell you that no, there is not a specific guardrail that you can use there. And for this case, what we have is uncontested.
I mean, is there some type of a guardrail involved in reasonableness when a fee greatly exceeds what the damages award was? And let's say, could it go up to $1 million for a $50,000 claim? I mean,
and I think, Your Honor, that it's got to be very specific to the case. And I would be very surprised if something could go up to $1 million related for a $50,000 case. But in this case, what happened is that we established the lodestar. It was uncontested.
It's about 4 times, I think.
Yes, Your Honor, it's about 4 times. But what we have is, and what the difference is in Smith, for example, is that we have the evidence that is shown that the amount of fees were reasonable and that both sides considered that amount of fees to be reasonable for what happened. And a great example of here in this case in particular is that we were done with trial in approximately 2 days. Okay, that would have been about $15,000 in fees. Trial went on for another 6. And it was shown throughout the case in terms of the number of depositions, the motions, and other sorts of things that the cost of litigation was increased greatly, mostly by Champion's side, because they were doing this out of principle. They were doing this based on reputation, as they testified to. And so they actually incurred more fees. They incurred $225,000 before trial, so approximately $265,000, $270,000 total. And they determined that those were reasonable. Now, we submitted a 38.7 letter recently, Your Honor. We just found a case from Houston that was very similar to ours, the Featherly case, where this type of thing happened. And one of the things it cited to was a Fifth Circuit case that talked about Newton's third law, that every action creates an equal and opposite reaction. I agree with you, Your Honor, that just on its face, that if you look at it and you're just looking at the numbers and say, oh, well, the fees were more.
Well, I mean, I see both sides of it being a lawyer, but I also wonder if there's some line, some test,
Well, and I think, Your Honor, that the court has already sort of laid that out a little bit in Smith, because in Smith, what it said very specifically is that it can be unreasonable, but then it says, in the absence of evidence that such fees were warranted due to circumstances unique to the case. And so it already provides that sort of guardrail there and says that it is possible to find something to be unreasonable, but we need to look at the case. We need to look at what happened there and whether or not there was a contest to the fees, whether or not there was some sort of evidence that's presented that would actually say that it was unreasonable here.
Let's on the question of what's unreasonable. Let's say there's $50,000 in contract damages, $100,000 in attorney's fees, and the side that's going to have to pay the fees says, "Look, we offered to settle this for $50,000, and we didn't need to come. None of this needed to happen. And so, yeah, you incurred those fees for this litigation, but it wasn't reasonable because this should have all been over." When we offered you $50,000 back then, is that grounds to zero out the attorney's fee award?
So, Your Honor, it could be, and that's where I believe they cite to the Meek v. Onstead case. If that was the circumstances where it's shown that there is no need for the attorneys at the time, if someone is offering to pay the full amount and someone still litigates anyways, then it could be that the attorney services were not necessary in that case.
My question is, if we open up that door to a judgment call about whether there was really a need for this case, that's an interesting question. And a lot of people might have different views on that question, and a lot of jurors and a lot of judges might have different views on that question. And given the breadth of sort of reasonable views about the necessity of various lawsuits, why wouldn't we just let a jury decide whether this was all kind of a waste of time and you shouldn't get your attorney's fees for it?
I think, Your Honor, that that's the extreme case that you're talking about. I don't think that the court needs to go there here because there is not evidence that there was the full amount that was offered
and that.
I'm departing from that hypothetical.
Yes, Your
I'm
Honor.
saying if you acknowledge that there are circumstances in which the jury is entitled to say this was a waste of time and you get no fees, how do we draw a line and say, well, but in this case they weren't entitled to do that, which seems to be maybe what they did here.
So the line drawing, Your Honor, is in the circumstance that you're saying. If there was evidence presented that all of the amounts awarded were offered before such that there was no need for attorneys at all, and it would have to be a very specific case where you have a very specific number and you have a very specific offer to pay. And that offer, of course, would have to be somehow binding.
Certainly that's an easy case, but in a lot of people's minds, there's a lot of litigation that is either unnecessary or unreasonable or both, that is not as egregiously unnecessary as the case I described.
I think it has to be limited to those egregious cases, Your Honor.
Why?
Because, Your Honor, the legal services have to be paid for effectively, and that if there is,
the statute says you may recover your fees,
but
which means you may not.
Well, but
someone's got to decide whether they're reasonable and necessary, and I just wonder, I wonder why that isn't just a pure jury question.
Well, under 38.001 and 002, Your Honor, even though it may say may, the courts have held that it is a must. It is a requirement to recover fees in that instance. And so it's not a situation where the jury can just decide we're going to award no fees.
Let me change the Chief Justice's hypothetical a little bit. If you have a case where $50,000 is recovered and $100,000 of fees are incurred, and there's undisputed testimony that that was reasonable and necessary, and the jury awards $50,000, you think that as a matter of law you get $100,000?
If it is uncontradicted, Your Honor, as in this case, if there's nothing else that shows that there is any amount that is less reasonable here, again, in the Ragsdale case, as the court said, it's like, look, especially when you have the opportunity to contest it.
So there's really not a fact issue then. I mean, it seems like, and if the amount were reduced on appeal, say there was a limitations issue and the amount of the recovery gets cut in half, so now you have $25,000, you would still say $100,000 because it was uncontroverted that was reasonable and necessary?
I do not think that there's a fact issue, as you're saying, Your Honor. I think that
we disagreed with you on that in Barker versus Ekman. I don't know if you're familiar with that case. I happen to litigate it, so I'm very familiar with it. But what we said there is when the amount involved in results obtained change on appeal due to limitations or something like that changes the amount recovered, you have to go back for a new trial on fees because it changes the amount involved in results obtained. And it sounds like what you're saying is that we overruled that case somewhere.
I don't think you need to overrule that case here, Your Honor, because we don't have that circumstance. We don't have a reduction.
Well, I understand, but it seems like it's the same issue. If it were binding in Barker because there was undisputed testimony, like this is a reasonable fee and this is the amount of time that was incurred, under your rule, we shouldn't send it back. We should just say, well, that's what you testified to, and the amount involved in results obtained doesn't matter at all, even if it changes. So it sounds like that's exactly what you're saying.
Well, Your Honor, again, on this record, when we have everything uncontroverted in terms of the lodestar being established, and there isn't any specific evidence that's been provided from the other side that shows that it is unreasonable.
Well, if you think Barker was wrong, I'd be glad to hear your argument on that. But I think one of the things that may be reasonable and necessary that it seems like we're not agreeing on, yes, Rormuth said, that the lodestar subsumes the fees, but it seemed like you were conceding in one of the discussions earlier that reasonableness could vary depending on the amount at stake, right? So to Justice Hawkins, you said if you're charging $3,000 an hour on a very small claim, that might not be reasonable, right?
I'm saying, Your Honor, under lodestar that there would be evidence contradicting that.
But the evidence is it's a $10,000 claim.
But Your Honor, I don't think that the amount of claim, again, just like in the respect of the Featherly case, it was $7,000 at issue. But the other side decided to spend $200,000 litigating it because they were doing it basically out of principle. The plaintiff in that case has to to keep up. Again, we couldn't stop after 2 days of trial and say, hey, we've got to be done because this is going to exceed. I mean, we spent approximately $60,000 just on trial. We couldn't stop and
And a
say,
jury can't say that's unreasonable based on the amount involved and results obtained.
I don't believe so, Your Honor. On this record, it is what was the hours
Well, I understand
necessary.
you agree. You say 0 is too low, but in response to my hypothetical about 50,000, if it was a $50,000 claim, they award 50,000 instead of 100. You said no, that's wrong as a matter of law.
I think based on the evidence that would be presented, if it's similar to this case, Your Honor, of what were the reasonable hours, which were not contested, and we have the other side having, and Your Honor, I'm out of time. Can I finish? Thank you. That the other side saying that similar amount of fees are reasonable.
But I think part of the premise of what we were saying in Rormus about what reasonable includes is that it has to be reasonable to the case, not just a reasonable amount of dollars sort of out in the world compared to what other attorneys make, but also reasonable in light of the amount in controversy and what you recover. I mean, that isn't that the way that all of those precedents can be read together? And to say that Rormus is not throwing out all the Arthur Anderson factors, but that those factors bear on reasonableness.
I believe that, as the court said in Rormus, is that the Arthur Anderson factors are subsumed, but it's very specifically in Rormus what you need to do to determine what is the reasonable hours and what is the reasonable rates. And then you multiply those together, and that's what you get. And here, all we have is uncontroverted testimony and evidence of those reasonable hours and those reasonable rates.
So under your theory, if the jury had said 210,000, you might have just taken it as a practical matter, but your argument is, as a matter of law, nope, 219,746, right?
Yes, Your Honor, in terms of what courts have held in those cases is that if they are uncontradicted, the jury doesn't really have that.
So your friend on the other side says, no, we did contradict it. We put in the evidence of attempts to solve this, whatever. I get that you say, well, that's not enough, but it's not nothing, is it?
I do think it is nothing, Your Honor, because they didn't provide any. Again, under Rormus, it is a fee opponent who seeks a reduction from the base lodestar amount bears the burden of providing specific evidence to overcome the presumptive reasonableness of the base lodestar figure. Nothing in the cross-examination, which was basically restricted to how much specifically did you remove for certain things in your segregation. And then just noting that there was an offer of like 10,000 before. None of that provides any evidence that actually shows any of the fees were unreasonable.
So let's assume that that's right, that zero, there's no evidence of zero. But the fact that the jury came up with zero, it's a little troubling, because even if that is a number that we can't accept, doesn't it at least provide a clue that the jury thought, well, this has not been a good use of attorney time. This has not been a good use of the judicial system's time. This is not necessary to have a trial that went this long, and targeting at what you all did. To sort of say it's binary, and the same jury who we spent the first half of this argument being like, well, this is the oracle of God. Everything is said is going to be harmonized. We're going to make it work. But in this instance, well, zero for attorney's fees. Just ignore those crazy people. That's a little problematic, isn't it?
Well, I don't think so, Your Honor, because I think it follows directly the precedent in Ragsdale, where in Ragsdale, a similar circumstance, what you are saying, respectfully, Your Honor, is that you never can decide attorney's fees from a trial court. You can never take it out of the jury's hands, and that's not what Ragsdale says, and it's not what this court says.
So I know your time's expired, but if the jury's awarding breach of contract or tort damages and they write zero in the line, you can move for a new trial, but you've got a very uphill climb to establish that as a matter of law you're entitled to tort damages when the jury says your number is zero. And I'm concerned that we've made attorney's fees, if we accept your arguments, then we're sort of creating a special category of attorney's fees where we won't accept low numbers from the jury in a way that we wouldn't even think about not accepting them in other circumstances.
I think the difference here, Your Honor, is when we're talking about breach of contract in accordance with the court's precedent of you have to award attorney's fees. Attorney's fees are mandatory in those circumstances. So when a jury says 0 in those circumstances, that is something that's an error as a matter of law. In a tort damage situation, there is not a similar provision that says that you must award damages. No
Well,
matter
there
what
isn't one
kind.
here. It says may only when it's reasonable and necessary. But I understand your point about the precedent.
Yes, Your Honor, but I think that is the difference here, is that a jury could find that there are not any tort damages that does not violate any statutes or raise any concerns there, whereas here for attorney's fees, it is different, and the court has looked at it differently.
Thank you, Mr. Trozes.
Sorry, Chief, just one other question. Sorry. I assume that this sort of thing won't happen now that we've changed our briefing rules. Page 24 of your red brief, you ask that we deny the petition for review. That's not going to happen. So the decretal language that you would like is that we would affirm. Am I correct?
Yes, Your Honor,
Okay.
affirm the judgment below.
Thanks.
Thank you.
Thank you, Mr. Trozes.
Thank you, Your Honor.
Mr. Vargas, you have 5 minutes.
Thank you, Mr. Chief Justice. May it please the court. There was a focus early on in the respondent's argument that this was not an express contract. And because it was not an express contract, that somehow that differentiates this case from some of the other cases, including Mincer out of the 14th court, as well as Christus out of the first court. And the reality is, whenever you take a look at those cases and you read them, actually, Justice Busby did a great job explaining and really kind of clarifying this whole body of law as to whether an express or an implied contract makes a difference when it comes to the effect on a quantum meruit claim when you have a breach of contract or when you have a contract that's been established. And the result of that, and what the court reasoned in Mincer, is whether it's express or whether it's implied in fact, a contract is a contract is a contract, and the result of any contract, whether it's expressed or it's implied in fact, is that you cannot, as a matter of law, recover under quantum meruit.
So
And
your friend on the other side says you needed to plead contract as a defense to quantum meruit, and you didn't do that, so any charger is waived. What's your response to that?
The response actually comes out of Christus, Your Honor. And in Christus, what you had is you had a plaintiff in that case who repeatedly invoked their rights under a contract, just like you have here. In fact, in this situation, the way that the case was pled, the way that the claims were pled, were that there were claims for breach of oral agreements, and solely in the alternative would you ever reach a question in quantum meruit. So just as the plaintiff in Christus repeatedly invoked their rights under the contracts, here the respondents repeatedly and actually solely invoked their rights under oral agreements, and only in the alternative did they attempt to seek recovery under quantum meruit. Now, what you have here is you don't have conflicting jury answers. What you have is you have incompatible, improper questions in the charge that was submitted to the jury. The charge, especially question number 3, should never have been predicated or conditioned on the plaintiff losing on their breach of contract claim. That was very improper, and it should have been conditioned on a question number 1, which should have been a predicate question as to the existence, terms, and scope of the contract. So again, when you have a contract that is impliedly found by the jury answering the question on breach, and it was done at the invitation of the respondents by submitting and requesting a broad form question, the result is you get no quantum meruit because a contract has been impliedly found to exist. The trial court took that out of our hands at the request of the respondents, and so with that, you never get a quantum meruit recovery. And also, by the way, you never get a
Is your approach consistent with the Fortune Products case?
It is because again, in the Fortune production case, Your Honor, what you had is you had a clearly defined set of contracts that weren't just limited in scope, they were limited in time, and there were transactions that fell both out of scope and out of time with certain parties. And so in that case, because you had a very limited scope and a very detailed contract, it was very easy to determine what fell outside of the scope of that contract. And here, what you have is a pleading on valid oral agreements and a request to instruct the jury on those very same agreements and a finding of breach whenever the jury answered the question as to no breach by Champion and breach by the plaintiffs, which, by the way, is also consistent with an attorney's fee award of zero. In other words, if the jury is finding there's no breach by Champion, but by the way, there's breach by the respondents, that makes a lot of sense when you look at the attorney's fee award and the jury decides to award $0 on attorney's fees. What you have is a jury whose hand was forced on a quantum meruit question, and that should have never happened because it's incompatible with breach of contract. Thank you all very much.
Any further questions? Thank you, Mr. Vargas. Thank you to all counsel. The case is submitted. The court will take another brief recess.
All rise.
Please be seated. We'll hear argument in case number 250317 in Re Home Depot.
Mr. Eady will present argument for relator. Relator has reserved 5 minutes for rebuttal.
May it please the court. This case arrives to this court via a Rule 91 procedure. The motion to dismiss was denied and Home Depot is challenging it. At bottom, Home Depot is arguing that it did not owe a duty to the injured motorist in this case to protect him from Werner's driver. At the broader picture, this case asks the question, what duty, what care is owed by someone who hires an independent contractor? It happens every day. The people hire independent contractors. We use people to ship goods. We hire people to mow the lawn. We hire people to take care of the children. And you make the list. Everyone can make the list. And it goes on forever. And it asks the question, what duty is owed by the people that hire the independent contractors? Now, it has long been the law in this state that one who hires an independent contractor, employer, hire, whatever the name you want to use, they're not liable for the torts committed by the independent contractor or their employees. And in this situation, we have a very confined record, and we know the relationship of the parties. We know that the shipper is Home Depot. They hired a carrier, which is Werner Enterprises, and Werner had an employee, Mr. Smith, who ran a red light and collided with the plaintiff, injuring and killing him. Now, Werner and its employee are both parties to this action. Werner has admitted in this action that its employee, Mr. Smith, was in course and scope of his employment when the accident happened. Later on, a claim was made against the shipper, which is Home Depot, and the question is, does Home Depot, under the allegations in this case and existing law, owe a duty to protect Mr. Garcia, the injured person, from the actions of Mr. Smith? Now, the allegations that are alleged are these. Number one, Home Depot failed to screen Werner and its drivers, including Mr. Smith. Screen. Number two, Home Depot willfully overlooked Werner's previous violations of the Federal Motor Carrier Safety Regulations, including 850 reportable accidents. We'll talk about that in just a second. And three, Werner was chosen by Home Depot over 1.1 million other carriers. And lastly,
do we need to make the broad holding about independent contractors that you opened with in order to say that you can hire if you hire a licensed shipper to ship your goods, you don't have to worry about car accidents that the shipper's drivers get into? I mean, shouldn't this probably be a lot narrower than how you opened?
Short answer is yes. Context is important. Context is important in hiring independent contractors. The context in this case is exactly what the court indicated. It is a situation where you have a shipper who needs to move goods to the retail stores. The shipper goes out and hires a national carrier who has a license, and the national carrier is hired to do that. Now, what does it mean when they have a license? Well, what it means is they have to comply with the law. And what does the law require of someone to hold a license? Well, if we look at the Code of Federal Register, now these were all regulations that were adopted, and this goes back to
So let me ask you a question. Let's say if this shipper was just as a matter of practice would hire drivers without checking on their DWI record.
Okay. So if it was a carrier and its carrier is licensed by the Federal Motor Carrier Safety Act, then they have to do that. They have to do that checking because they're required by law to do that. And if we looked over...
Who would have to do that?
Beg pardon?
Who would have to do that?
The motor carrier. And in fact, the motor carrier has...
You mean Werner here?
Werner. Mm-hmm. Werner has to, by law.
And
Werner
so my question is, would Home Depot have any responsibility to check and make sure that Werner is complying with those regulations?
No. That would be the responsibility of the federal government. Now, the federal government has places not on the shipper, The shipper has no responsibility under the Federal Motor Carrier Safety Act.
And so
Only
there's no limit to
carrier.
that? Is that what you're saying? Is there no limit? And there may not be. I'm just asking the question. But is there no limit to how egregious the practice was for the shipper? Let's say they were only hiring people that, this is ludicrous, I understand that, but let's say they were only hiring drivers who did not have a driver's license because it saved them money.
All right. If they're a federal motor carrier and they're regulated by the Federal Motor Carrier Safety Act, then they get a license. And when they get a license, that means they've complied with all these obligations on who they hire, doing the background check, doing the alcohol check, every year, running another list of, what their traffic violations are, making sure they have a medical certificate. They have to do all of those things.
Would
And in
this be a
addition,
different case if there were allegations that tied to this accident? In other words, there are allegations that this driver was unlicensed, or even that in hiring this particular driver, Home Depot knew the driver was unlicensed.
No.
If there were allegations like that, would you still say the same result should obtain?
Those aren't the allegations,
Right.
but if the allegations were that Werner did not have a license, Werner was not a licensed carrier, then that would be a different set of allegations. Those are not the allegations. The allegations are that Werner didn't do several of these, that Home Depot did not do what Werner is obligated to do under law, right? We know that Werner, under law, was qualified as drivers, right? We got two of these allegations in the pleading that said that Home Depot should have done that. Now that's Werner's responsibility, not Home Depot's responsibility. That's why you hire an independent contractor, is so you don't have to do those things. The independent contractor is responsible, and here it's even more responsible because the law requires them to do those things. Plus, the federal government regulates them and determines whether or not they should keep that license.
So if instead you just went and found some guy on the corner and said, "Can you round up a few truck drivers?" He said, "Sure, I'll do that. I'll be your contractor," and he brings 5 guys and off they go. Would it be different for Home Depot then?
So if it's it's a carrier that's not one that's
Not even a carrier, it's just some guy who gets some buddies, says, "I can have him run." He's an independent contractor in a sense, I guess, right?
Right. That's exactly right. So we take an example of let's say that you're going to ship plutonium from the Pantex plant down to Andrews, and you decide you're going to use your neighbor to do it, right? He's got one truck, and that's who you use. Now, that's kind of a completely different situation as opposed to when you have a carrier who goes out and hires a national carrier who has to comply with the federal regulations, has a license, and there's things that come with having a license.
Is that the stuff that's doing the work? Is it's a national carrier that's licensed? I mean, what if it's a carrier and they've got a proper office, but they're not licensed at all?
A carrier that's not licensed to drive and doesn't have individuals who have a license to drive, that would probably be an incompetent carrier.
Well,
What
so what's the
about-
liability for, I'm sorry, just if I could just get you to tell me what would be the liability for Home Depot in that situation? I get that it's an incompetent carrier, but would you say that our case here, if it had not been Werner that had the license, but have been another one, like just go full bore?
I mean, that's not the allegations here.
I know,
Right.
but
That's
why it's a hypothetical. Is that what's doing the work? That it's a nationally regulated thing with the license from the federal government? Is that what's doing the work, or is there something else in the fact that it's just an independent contractor? Where is the magic here?
Yeah, that's doing the work. That's doing the vetting. Federal government did the vetting. Home Depot went out and hired a motor carrier that was licensed by the federal government, has an interstate license, and again,
So you take any of those variables out, and we have a different outcome as far as you're concerned.
right. Right. That makes a big difference on the carrier you hire, and that's why Home Depot goes out and hires national carriers to deliver their goods to merchandise to retail stores.
I'm
What
sorry,
about
Justice.
Thank you. What about the permutation where the shipper is different? So here I imagine that Werner's clients, customers are generally commercial. What if the situation is me, one person, walking into FedEx or UPS to mail a care package to my daughter?
Right.
But what then? Is that kind of business which is oriented toward individual, you know, people shipping small things?
Yeah,
Is that also governed by the FMCSA, and is there the same kind of checking going on there? So, in other words, is the rule we announce here going to apply to work that I would have to do, investigation that I would have to do as an individual shipping a box, in addition to whatever the burden would be for Home Depot?
So yeah, you bring home the analogy to more a personal level, but this one is easy because in that analogy or that hypothetical, you're using FedEx, you're using UPS. So you're actually using someone who is licensed by the federal government.
That was my question, is has the federal government done the same work to
Right.
investigate
So it's really
their drivers?
right, and it's really easy to check. So you go to their website, you put in the name, and you'll pull up their DOT number, and you'll find out if they've been rated. Like only 4% of them have been rated, but they've been rated, and they'll be rated as satisfactory, conditional, unsatisfactory, or not rated. Now, if they're unsatisfactory, they can't drive at all. They can't operate. They can't have a DOT number on the side of their trucks. So you can do that if you want it. And the question is there an obligation in that situation to do any kind of vetting? Again, same thing with the person who mows your lawn, the same person that takes care of the kids, delivers the package, does the pest control at your house, all of those things. What duty is owed in those situations by the person who hires an independent contractor?
If you're relying on Werner's compliance with federal law and all the attendant regulations, is that suitable for a Rule 91A motion, or does that require some evidence outside the pleadings demonstrating Werner's compliance with federal law?
It does not. It fits in with the Rule 191A really easily because everything here is undisputed. Number one, we know the parties, right? We know we got a motor carrier, we know a shipper, we know we got the injured party, we know the legal relationship between the parties. We've got all the pieces here, and we've got their allegations, which is probably the best part of this Rule 91A challenge, because those allegations that are actually in the pleading, well, two of them are vetting the driver. Those are things that the motor carrier must do. The other two is you didn't go through all their accidents, right? Didn't go through all of their accidents for 2 years, 840 reportable accidents, and you didn't do this comparative analysis of 1.1 million carriers. You just picked Werner, and you didn't go through the whole list. Well, neither of those or any duty that would be applied to someone who's selecting a carrier. And the reason why I think it's twofold is first, that doesn't fit with any existing case law. Even if we go back and we looked at the old case law, negligent hiring, negligent selection of an independent contractor, there's no requirement like that. And there's especially not in this particular context. But then if you said, well, maybe there should be. So this is a lot like the elephant insurance case, in the sense where, in that case, the insured was suing the insurer. They came to court and said, look, there's a duty between the two of us. It's called good faith and fair dealing. Read Arnold, read Aranda, and we know there's a duty, and it's just a case of breach. It's kind of the same argument they're making. It says, well, there's this duty of negligent selection, and it's out there, and it's just a question of breach. The problem is those cases don't address this situation at all.
Do you want to address the United Rentals case?
Beg pardon?
United Rentals.
United Rentals especially does not address this case because we have affirmative misconduct. We have the control. Control's always been a big issue in the independent contractor. If you exercise control, they're no longer independent. They're your agent. So the more control you exercise, then the more responsible you are. So here we have United Rentals. They're very responsible because they load the truck. They know the bill of lading is the wrong bill of lading. And then when they find out that the equipment, which is not going to fit under the underpass, is already out there on the road, they do nothing about it. So we have an affirmative conduct as opposed to just simply hiring a carrier like Werner to ship an ordinary load. All this is involves.
Go ahead.
Just to piggyback on Justice Bland's good procedural question, I know that we do this sometimes, but why should this court use the extraordinary writ of mandamus to go get involved at the motion to dismiss stage in a district court? Why? I know that we've done it, but why is it a good idea? Why shouldn't I be concerned about this court doing that sort of thing?
Sure. Okay. We have, in this case, Werner is in the case. Their employee's in the case. Werner's admitted liability, vicarious liability for their employee. There's no need for the shipper to be in this case under these facts and the allegations at all, much less what exactly discovery are you going to get after 2 years that's going to change any of this? The answer is none. We know the legal relationship of the parties. There is no sense in keeping the shipper in the case at this point in time. Now, if there was a reason for a duty to exist that would make the highway safer, that would be one thing. But here, it's just the only result is, well, you shouldn't have hired Werner, you should have hired someone else. But that's not a reason to create the duty because it's not going to change the outcome in a red light case.
Mr. Eady, I think I heard you say to Justice Young that the federal licensure part of it was important. I've got the first amended petition with me. Is there a paragraph that alleges the federal licensure in here?
It is not, Your Honor.
Okay, and so could you walk me through how we would take that into account at the Rule 91A stage?
Sure, because the challenge that Werner, or the challenge that Home Depot made, first of all, it set out that it was not the motor carrier and therefore did not owe the duties of the motor carrier.
Right. I thought I heard you say to Justice Young and maybe Justice Huddle that this is a federally licensed carrier. I think Justice Young said if you take away one of those pieces, different answer. You said yes, different answer. So I took that to be suggesting that the federal licensure was important, which is fine. I'm just wondering if that's actually part of the case at this stage, at this Rule 91A stage. And I think to do that, I'm supposed to look at the petition. So I guess that's what I'm looking for clarification on.
What they're missing in the petition is any allegation that Werner is not federally licensed, not insured, is not compliant with Federal Motor Carrier Safety Administration regulations. That's
but we don't
missing.
know.
You would need that.
But we don't know from the petition that they're required to be.
If they're a motor carrier, by law, they're required to be.
Where do we get that?
That's a fact that's not disputed, that they're a motor carrier and they're licensed as a motor carrier.
But to Justice Hawkins' question, don't we have to find that in the petition at the 91A stage? I mean, that's a great argument for summary judgment.
No, because you don't need it at the petition stage because we know the relationship of the parties. We know they're a motor carrier, and we know that because of the absence of the allegation that they're unlicensed, that they were a licensed motor carrier. Their question is there a common law? Not that they're not a licensed motor carrier, because if they were not a licensed motor carrier, it'd be there. This is one of those facts that can be very easily determined. It's you can take judicial notice of it. It's right there on the website. Everyone can make that determination. Do you have a license?
Any further questions?
Again.
Thank you.
Thank
you, counsel. We'll hear from the real party in interest.
May it please the court, Mr. Moore will present argument for the real parties in interest.
Mr. Chief Justice, Court. I want to get to the duty, but I certainly want to start with the procedure. So what I would like to do first is to start with a response to your question about is this the right vehicle? And Justice Bland, your question about should you be considering facts outside the pleadings in a 91A motion? And then Justice Busby saying, this sounds like a great argument for a summary judgment. And I want to start there because if Home Depot wanted the court to consider evidence outside of the pleadings, they should have moved for summary judgment. And they shouldn't have filed a 91A motion. And I want to refer the court to its own opinion in In Re Farmers, which is cited in our brief at the Farmers case at 275, 276, where the majority says the dissent does a great job arguing a summary judgment for the party, but that is not what they filed. They filed a motion to dismiss. So we're going to consider the motion to dismiss. That is critical here, Justice Bland, because all of the facts that Home Depot is relying on, that they were licensed, that they were a carrier, that the FMCSR applied to them, none of those are in the petition, Justice Hawkins.
Except for the absence of the link between the injuries in question and the duty? In other words, are the allegations of Home Depot's negligence in any way tethered to what happened in this accident? Or is it more carrier should not have been on the road at all?
That's a hard question to ask at this stage, and this is why when this all happened, there wasn't any discovery. So I know the answer to what kind of driver the driver was and what the discovery revealed after this, but it's not in the record. But if you look at mandamus record at page 23, it alleges how Home Depot was deficient. And that kind of leads me to the duty argument that I want to address, because he posed it as a question of what duty should a shipper have? And I think that's half the question. I think the whole question is, what duty does a shipper have if they know, or they should have known, that the carrier they were hiring was incompetent? And in this case, we have pleaded they didn't just have 850 reportable accidents. They had 250 injuries and 25 deaths. That is a death a month in the 24-month period preceding. And if you look at the mandamus record at 23, we allege that Home Depot knew and acted with willful disregard at hiring somebody who was an incompetent shipper. And this is critical because it's Warner. Warner is the dedicated shipper for Home Depot. Home Depot has somebody embedded at Warner.
But I think they're saying that regardless of all of that, they don't have the responsibility to do that if they can rely on licensing, et cetera.
They can rely if they don't know better. And under the restatement 411, and I'm going to talk about the preemption argument in a minute because that's what it is. But under restatement 411, a shipper or Home Depot has a duty when they're hiring a contractor to do so reasonably. And if they are aware that the carrier is incompetent or unlicensed, then they have an obligation to not hire them.
I want to sort of stay right there because I feel like, tell me if you disagree, we can insert sort of my name or your name for Home Depot sort of across the board, right? No matter what we're shipping, whether it fits in an 18-wheeler or a small package. Do you agree with that?
I do agree with that.
Okay, so then I wonder, what would I do to discharge the duty? Do I need to look only at the general carrier's accident record, at those 800 incidents and number of deaths? Do I need to understand who the actual driver of my truck is going to be? I mean, how do you discharge the duty you're committed to?
I think if you go back to this court's analysis in Phillips, and it talks about the sensibilities of the parties, you're talking about if you or I walk into a FedEx shop, what is our obligation to find out?
Yeah, or if you tell me that's a different case and I don't need to worry about that.
That's what I'm saying.
Okay, I'm listening for a limiting principle that distinguishes me from Home Depot.
I think that, and that's what I'm saying. I think the burden on you or I when we walk into a FedEx office to drop a package, when we don't have any idea who the driver is, we're hiring FedEx. That is different than somebody who is Home Depot, who has an exclusive relationship with the carrier in this.
But is there a burden at all, or would you say that in the circumstance where you walk into a FedEx that you don't have a duty?
I don't believe,
as an individual shipper, if you're just walking in and handing the package, do I have a duty to do something?
I don't believe that I have a duty when I walk into FedEx if I don't know the identity of the carriers.
Well, it's FedEx.
No, let me back up a little bit. I know that FedEx, well, actually, one of their cases is a FedEx case where they say they weren't acting as a carrier. FedEx can be a shipper. So when I walk into a FedEx, that doesn't tell me that FedEx is even the carrier. FedEx actually acts as a shipper and hires carriers like Warner and other, the 1.1 million carriers. I don't know when I walk in that FedEx is the carrier.
Okay, assume that I'm using some company that is, that maybe UPS is the carrier, or I don't know. But if I'm using a company and I know they're going to be the carrier, do I have a duty?
I think you have a duty to act reasonably under the circumstances. And if the circumstances are that you know or should know, as Home Depot is. That's what I think is different in that construct. If you know or should know that somebody has an unsafe driving record, and you have a relationship with Warner like Home Depot does, then you have to discharge it reasonably. I think that is a different circumstance than when somebody walks in and they don't know, first off, if it's a shipper or a carrier, and secondly, who they're using.
Does that person get out under 91A, or you're like, sorry, nope, we'll go through summary judgment, maybe trial?
Well, that's where I would go to this court's opinion in United Rentals. When assessing the duty here, it depends on the facts, and that's what we don't know yet. We have not done any discovery in this case to determine.
But do we know that in the hypotheticals that Justice Tuttle and Justice Busby were talking about? We need to do the discovery. Like, what did you know? You were, shipping the vase from grandma to somebody, but did you really know? Maybe you knew that this guy, maybe it wasn't FedEx, maybe it was your local Porter's, we'll get things for you. Well, come on, that's not FedEx. Did you check and see what their driver record was? Let's do a little discovery. There's no 91A for that, right?
What I would say there's a 91A for is the allegations in the pleading. This court has said in Ray Farmers in Bethel that you accept the factual allegations as true. And what makes this case different than I think Justice Tuttle and Justice Busby's is, if I actually could allege and put my name on the pleading as a good faith pleading as a lawyer, that you knew when you went into a small FedEx shop in a small town and they only have one driver who does all the FedEx packages, and you knew that they were reckless, incompetent, or unfit, and you handed it over anyway, that might be a different thing, because you have to accept those factual allegations as true. And that's what the trial court did here. It accepted that the factual allegations that Warner knew, that Home Depot knew that Warner was unsafe and had a terrible unsafe record and hired them anyway.
Is there any allegation connected to this accident or this driver?
There is an allegation.
With respect to Home Depot's involvement or knowledge or constructive knowledge or anything like that?
The allegation in the petition is that they knew that they were an unsafe carrier and they hired them anyway.
As an unsafe carrier as a general matter with respect to thousands and thousands of drivers and trucks. I'm asking, is there any allegation as to this driver or this truck or this wreck having anything to do with Home Depot?
There's not an allegation about this driver. There's an allegation that they knew when they hired Warner and had a dedicated relationship with Warner that they had a history of unsafe accidents like this one.
So if Justice Huddle were to, instead of going to FedEx, she went to Werner, maybe it's a big care package that she's sending to her daughter, then Justice Huddle would also have to go to discovery, because had they consulted the same 800 reportable incidents and everything, then too bad. If the care package on the truck hits somebody, same result.
Again, Justice Sullivan, I think the court is constrained to the pleadings about what was pleaded. If somebody pleaded that Justice Huddle knew when she went in, what if she has a friend or family member at Warner and somebody alleges in a petition she had actual knowledge that the person she was handing it over to had a very unsafe history? I think that is a different thing.
Well, the fact that there's no allegation at all about this wreck or this driver or this truck or this situation seems to me to distinguish this very clearly from United Rentals, in which the facts were that they were involved in the loading of that truck. They were part of the reason why that truck was unsafe on that day, which is a very, very different situation from just sort of a generalized obligation to assess this company at a broad level. So I'm struggling with the reliance on United Rentals.
Well, I think the reason maybe is that it is a struggle because you considered United Rentals after a jury trial and a jury verdict, and all of the facts were developed. We weren't in the dilemma of a plaintiff filing a pleading in good faith, and before they can do it.
But you filed your pleading. It contains no allegations whatsoever about this particular situation. And if we're honest with ourselves, it would be implausible to do so. I mean, Home Depot is massive, Warner's massive. The idea that Home Depot was intimately involved in the selection of this driver or this had any factual connection to this wreck as existed in United Rentals is, you're not alleging it, so I don't have to say that it's implausible. But the idea that that's going to come out in discovery is quite a stretch.
I think what has come out in discovery is that this was a driver who had a bad history of reports and doing things like he had done here. And if Warner hires drivers like him consistently and Home Depot knows it, then it's just a negligent hiring claim under the restatement that this court has said. I'm going to refer the court to the Endeavor case, where it said we have never explicitly adopted a negligent hiring claim or defined the scope or the elements of it. But what we have done is we have recognized that it's like a negligent entrustment case. And in a negligent entrustment case, if you hire somebody unlicensed, incompetent, or unfit, then you are liable under a negligent entrustment theory. That is all we're alleging here, is they hired somebody who was incompetent, because the restatement in the Puckrind case they cite says a competent carrier is a competent person would be someone who a reasonable person would expect that they would have the skill, experience, and knowledge to perform the conduct or the activity safely without posing a risk.
If a court were to hold that that Werner's company-wide safety record is such that Werner's potential customers have a legal duty not to hire Werner, that would put Werner out of business, right?
No, I think what it might do is compel Werner to drive in a more safe manner and to hire safer drivers. And I want to take this.
How could anybody after that holding hire Werner? I mean, there's no reason to. You could hire somebody over here who, I suppose maybe has a slightly better safety record, and it'd be crazy to hire a company after a court has decided that you can be liable for that company's wrecks.
I don't think the court would decide on this record, on these pleadings, that it's accepting as true that Warner has a duty. I think the proper vehicle would be to deny the mandamus petition and say what the court said in United Rentals and Phillips and its other duty analysis. We're going to determine the facts and whether they give rise to a duty on the facts that are unique to the case.
And I guess I'm asking whether at this stage, part of our assessment of the plausibility of your allegations, both legally and factually, if we would take into account what seems to me to be the reality that if your allegations were to succeed, you'd be putting Werner out of business.
I think.
I mean, can we consider the sort of logically necessary implications of your theory of liability in assessing whether it has any legal viability?
When you're considering whether our petition can withstand a 91A motion, I don't think you should consider that. Have we alleged something? If we could, let me just take a step back, since we don't know what the facts are. Let's just assume that there was email correspondence between Home Depot and Warner, who was embedded in a dedicated carrier, and we had a vice principal at Home Depot emailing a vice principal at Warner, and what the vice principal at Home Depot said is, I appreciate that you have the worst safety history of any of the 1.1 million carriers driving on the highways. But I also appreciate that you're doing it for 80 cents on the dollar of what the other carriers will do. If the facts prove that, we've met our burden on a pleading analysis. And I think in that circumstance, if the evidence revealed that, and this court got the verdict like it did in United Rentals, and it reviewed that evidence, would it consider the impact on Warner under those set of facts? I don't think it would consider, we can't write an opinion on these egregious facts if it will cost Warner its business. Maybe that would be the impact of it. I don't think it's a proper consideration for the court without a full record.
Mr. Moore, our conversation this morning, particularly your colloquy with Justice Huddle about, an individual walking into FedEx to ship something to grandma, it makes me wonder, wouldn't it be much simpler to just adopt the blanket bright line rule that Mr. Eady led off with, which is if you hire an independent contractor, that's it. No liability, game over. Can you give me your best pitch for why we shouldn't adopt that rule?
Well, there are two things. One, it's contrary to United Rentals, which this is a preemption argument where the court said just because you've one party has a non-delegable duty to comply with a statute doesn't eradicate the potential for other common law duties, which we've stated, which is a common law duty to hire somebody reasonably, to not negligently retain somebody you knew or should have known as incompetent. So I think that is the answer to it. The other reason for it is This court has never, and they haven't cited a single case, even all of the preemption cases that they've cited recognizes negligent retention as a cause of action. And then the courts diverge and they say, well, it's preempted because it's related to transportation, or it's not preempted because it's within the safety exception. They haven't cited a single case where any court has rejected 411 of the restatement second or third and said that there should never be a circumstance, no matter what you know, where you can never be liable for hiring somebody if you know they're incompetent, unfit, or unlicensed.
So you mentioned the restatement third. What about, why shouldn't we look to that? If we're going to look at the restatement, why shouldn't we look to the restatement third rather than the restatement second? And if we do that, is the actor's negligence a factual cause of the harm within the scope of liability as alleged?
I think if you look to the restatement third and section 55 of the restatement in comment B, where it imports if there's a violation of 411 under the restatement second, under comment B in section 55, then they have liability under the restatement third. So I disagree with the notion that the restatement third nullifies a negligent retention claim.
What's the allegation that the actor's negligence is a factual cause of the harm here?
I think if the court will look at the mandamus record at 23, where we've alleged what Warner knew or should have known, if they hire somebody who is employing incompetent drivers and they know it, and an incompetent driver causes it, it would be the Endeavor case. It would take two parts, negligent entrustment and causation. If a negligent driver who was incompetent caused the accident, and the carrier and the shipper knew they were hiring incompetent drivers who were causing accident, that will meet the proximate causation standard.
Before you're out of time, the same question that I put to your friend in opposition about whether and why it would be appropriate or inappropriate for this court to use mandamus relief to reach down into a district court and say something different with respect to Rule 91A motions to dismiss. Can you hum a few bars on that, please?
It's hard to imagine why, for me, the court would grant mandamus relief on this record when it is predicated on their reliance on facts that are outside the record. They've dropped a link to the Department of Transportation. They're alleging that they're licensed, that they're insured. None of that is part of the factual record. It's not part of the pleading. There is nothing before the court except material outside the pleadings. And if the court...
If the law were that you can't be liable for hiring a licensed shipper, let's say that's the law, wouldn't you need to allege that they're unlicensed in order for your petition to survive Rule 91A?
If the law was that you could not be liable for hiring a licensed shipper, then I think you would have to plead something, an exception to why you would be liable anyway. That is not the law.
Well, that's kind of why we're here. I mean, well, if we decide that the law is that or something like that, then doesn't that sort of flip things? And it's your petition's lack of an allegation that they're unlicensed that is the reason why this all fits cleanly within 91A.
I don't believe so under United Rentals, because the court held that because there's statutory compliance, and that's what that case was. It was a trucking company. If there is statutory compliance under United Rentals, the court said it doesn't eviscerate the possibility of a common law cause of action. And I guess it goes to Justice
when the
Hawkins'
defendant
question.
is intimately involved in the circumstances of the accident.
Well, the court would have to, the record, the example I gave earlier about if there were discovery that showed X, the court would have to take the position that there is no set of circumstances that you can ever prove that will ever satisfy a negligent retention claim. And Texas has never gone that far, and I think this is a bad vehicle for it to go that far without a factual record.
Any further questions? Thank you, Mr. Moore. Mr. Eady, you have 5 minutes.
Thank you. We'll start with this question of duty, because there's another way to get to the same result of why the trial court erred, and it's just based upon duty. So I like this notion of addressing the Phillips factors, and so let's do that. If we do the Phillips factors, we can double check our math, right? Make sure we got it right. So what was the risk of harm? It was running a red light. Okay. If we take their argument on the duty that we should vet 1.1 million carriers. We're supposed to investigate all these accidents that are, quote, reportable. Now, again, that just means someone died in the accident, a vehicle was towed away, or that someone had medical care away from the scene. It doesn't do anything on responsibility, okay? Let's just say that they had all of that, and that was what they say that the duty should involve. We're going to make the shipper's conduct tortious. For what reason? To prevent someone from running a red light? There's a complete disconnect, and it's the same disconnect that you see in the Fifth Club versus Ramirez. So in the Fifth Club versus Ramirez, there's a second claim that goes to the jury that this court has to address, and that's a claim of a negligent hiring of the security guard. And so the argument by Mr. Ramirez in support of keeping that jury finding was that you shouldn't have hired him. And the reason you shouldn't have hired him is because he was an off-duty police officer. Now, he shouldn't have been off-duty doing moonlighting for you because his job requirements said he couldn't do that. Now, if he couldn't do that and you didn't hire him, because you'd agree you wouldn't hire someone who couldn't be working for you, then he can't be there on the night of the accident. And if he's not there on the night of the accident, then when Mr. Ramirez shows up intoxicated, there's not an altercation. And this court says, no, those two are disconnected. And that's the same problem we have with the duty issue. And it's the same issue that Justice Busby that you hit on and looking at the restatement third. So is the selection of the carrier a factual cause of them running the light? It is not. So if you ordered, let's say that you wanted a Domino pizza tonight. You ordered Domino's pizza and they come out and on the way to deliver your pizza, they're in an accident and they kill 4 people. Did you fail to vet them before you ordered that pizza? Is there something tortious about just hiring Domino that caused that accident? Absolutely not. Those two are completely disconnected. You wouldn't make the conduct tortious in that situation to prevent someone from running a red light or being involved in an accident.
Is the analysis there that I had no duty? Like there's just no duty? Or is it I had a duty, it's just super, super easy to satisfy that duty? And I did it by, finding someone who had a reputable website or something. I don't know.
Your Honor, I think there's 2 answers to that. One of them is the duty that they argue for is too onerous that you couldn't ever do it. There's no one sitting at Home Depot that's going through a reportable accident saying, well, here's one responsible, here's one they're not responsible. And you're not vetting 1.1 million carriers every time that you need to have hammers delivered to a retail store.
The erratic driving of youthful pizza delivery boys is an interesting topic to bring up. I mean, it's so commonly known that it's a joke in Home Alone.
Right.
We all know that the Domino's driver might be,
but it should
might have smoked something he shouldn't have, or might not be, should be on the road. But is it our fault or is it Domino's fault when he runs somebody over?
It's a real interesting issue, and this court has never addressed this whole issue on negligent selection. And what you do see in the older case law is a very limited inquiry. So let's say that the inquiry, we hired the trucker again, and this is the neighbor or something. And the neighbor says, I've got a license and I delivered for you before. And then the courts will say, well, that's good enough. No liability. Most of those old cases do not find liability under negligent selection. So let's reverse that. It's okay. That's what the court said in its opinion. So don't we have to have some kind of allegation in the pleading that would match that? Did not inquire. It never used the trucker before. At least something like that. And we don't even find that here. But the big thing here is the social utility. If you try to impose this duty, we've already have people that's responsible for vetting the drivers. That's the carrier. That's why you do it. That's the purpose of hiring independent contractors. The general rule should control under these facts. These allegations don't get them there. So,
any further questions?
For the mandamus relief that you're asking us to grant, would you have us tell the district court dismiss with prejudice and without leave to replead, or
yeah, sure.
or would you be fine if we said dismiss, and you can give them leave to replead in light of whatever we end up saying in this opinion if you win.
My understanding of the law is that they get one chance, and if it's challenged by Rule 91A, and it should be dismissed on Rule 91A, it's with prejudice and without a chance to replead. Could be wrong, but that's my understanding of the way that works.
Thank you.
Not if we clarify the law, right?
That's right.
Any further questions?
Thank you, Your Honor.
Thank you, Mr. Eady. Thank you to all counsel. The case is submitted. That concludes the argument set for today, and the marshal will adjourn the court.
Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.